for 3 years, over and over, nothing. And then he finally got tired, sold it, and then this guy bought it. He was from his dad was a senator from Deming. Within a few months, 2 or 3 months, he was able to build a home, built a story home right there and whatnot. And yet, this guy had been trying to, couldn't do it. So, in this case, also, I know that they've been putting for to be able to subdivide and to build and whatnot for quite a few years, because they've been doing it before me also. And they're not being allowed. So, sometimes, there's rules, but there's also rules that need to be looked at, that can be changed. It's just like in the service, they got rules and whatnot, but sometimes you got to stray away from it. You can stick to them all the time. And I think that it's only fair to allow her to go ahead and do this. I think that she probably built it, and it's not a manufactured. It's a manufactured home, and I'm sure she'll be putting trees and whatnot, walls. I mean, you won't even notice if you pass by, But I think that we need to start getting staying a little bit more open-minded to stuff like this, and I think that she needs to be given a chance. Her parents been here forever and ever, just like we have, and I don't think we need to be driving them out of here. So if you please stay open-minded to that and give her a chance. Thank you.
Thank you, Mr. Cotto. Any other public comment? Okay. Seeing as there is no other public comment, we'll move on to our next order of business under action and consideration for new business. Approval of PZHAC case 062009 for 2320 Calle de Santiago, submitted by Eric Leafield and Trina Witter, requesting approval to construct a fence around the north, south, and east property line in the historic residential zone.
So moved.
Second.
Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Nevarez. We will open it up for discussion. And Eddie, if you can just give a background.
Yes, good evening, trustees, mayor. My name is Eddie Salazar. I'm with the Community Development Department. This case number 062009, 2320 Calle de Santiago. It was submitted by Eric Leafield and Trina Witter, requesting approval to construct a fence around the north, south, and east property line. The zone is historical residential. Mr. Leafield and Mrs. Witter have submitted a property plat of survey to reflect the property's legal boundaries. On this survey, they have outlined where the walls will be constructed. The north property line will be a 6-foot coyote fence. On the south property, there will be a combination of a coyote and adobe fence. This boundary line will also have a 2-entry driveway gates and a man gate. The boundary line is offset from the street 10 plus feet, meeting the MTC of Messier Town Code 18.60.340G requirement. The east property line, it being the front of the property, will be constructed of adobe with a wooden gate and trellis type of the design. This property is on the corner of Calle de Santiago and Picacho. Messier Town Code 18.60.340D. Side triangle of 30 feet has been met by the design submitted on the elevations documents. Between their property and the property adjacent to the north is a storage type building / structure. This building structure was in place when the property was bought and subdivided by the previous owner. Mr. Leafield and Mrs. Witter were not able to acquire a right of entry from the neighbor from the north. Messier Town Code 1835.060D 1 through 5. It is required in the historic residential to obtain a right of entry form from the adjacent property owner where the fence is going to be constructed. Due to and once if you are not able to obtain the right of entry, then the code requires for you to have a 7-foot setback, right? Because at that point, the fence is no longer required. It's considered a fence, is considered a structure because it's not on the perimeter itself. One of the things I like to point out, though, is that there is a building, as I mentioned, in between the property lines that goes right through the property lines. As a matter of fact, the storage building is divided. There's a wall inside of it that divides the structure to both properties when it was sold. And according to our code, also included in our code states that, I wrote it down here, we see the no boundary lines go to the pre-existing building that appears to be a storage according to Messiah Town Code 18.60.22. I'll read it directly. This is straight out of the code book. Every required front, side, and rear yard shall be open and unobstructed from the ground to the sky, provided that when the common boundary line separating two or more contiguous lots is covered or partially covered by a building, or when two or more such lots are used as a single building site, such lots are a single building site, and the yard spaces as required by this title should not apply to the common boundary line. So even though that Mr. Lutfield and Mrs. Witter are not able to obtain the right of entry from the neighbor, which would require them to have a 7-foot setback, having that building in between those two properties, as I just read, does not require a setback on that. So I'd like to recommend approval for this request to be able to erect, again, fences around the east, north, and really south of the property. And I stand by for any questions.
Thank you, Eddie. Trustees, questions?
The storage building that you described, and it's on the plat here, is a survey.
Correct.
Is it, what year was that built, you know?
I can't, off the top of my head, person-wise, I'm not able to answer that question, but the applicant is here. In case you would like to ask him, I can ask him, or you can ask him to come to the podium. No,
It was built because it's built on the property line, apparently, but it was before it was subdivided into two lots.
correct. And that's what happened. It was owned by one person. My understanding, the person adjacent to that is the original owner. They subdivided to be able to sell part of that property. And according to the plat of survey here on record, January 10th, 2007 is when it was recorded with the county.
And along that north side of the property, that's where the coyote fence is going to go in.
The coyote fence is going to be on there's a drawing right here, part of your elevations. Yes, correct. Our north elevation is the fence with the existing building there.
And that's the one that the consent to enter, I mean, whatever it's called, it was not obtained, right? Because the neighbor didn't want to give it.
The right of entry?
The right of entry, yes.
Mhm. The one on the north of the property line, correct.
Mayor,
Trustee.
yeah, I recall when this came in front. I think I was the only one on the board 4 years ago. When this came to us. And I know the issue back then was safety for Mrs. Leafield, which was of course a concern to the members of the board at that time. But also brought it by the applicant was that the concern that the town was infringing on property owners' rights, which begged by, because the ordinance does state that we need to have the right of entry. And the town attorney at the time did side with the town that we were authorized to request in our ordinance that right of entry. So now it's before us again, and again, the ordinance states that there needs to be that right of entry. It's like we're trying to find ways to get this built without following the ordinance. The question I did have is in the packet. It says, impacts to the neighbor. We do not want to trespass on the neighbor's property, but there is currently no way of knowing where the property line is located. So we have that we don't know where the property line is located, yet they're gonna build a proposed wall fence constructed entirely on their property. But that's what's in the plat that defines where their property is. But yet it states that they don't know where the property line is located.
Well, we can come forward.
Yeah, I'm just seeking clarification.
Say your name.
Yeah, my name's Eric Liefeld, Town of Mesilla. And yes, I remember it all very well, thank you. We absolutely know where the property line is. The lot is staked. It is not visible to anybody walking around on the property. And in fact, the motivation for putting up a fence came from the neighbor for that reason. She wanted to just put up some chicken wire and some stakes. And we explained to her that we couldn't do that, that it had to go through the town of Mesilla. So yes, we know where the property line is, and the stakes are, the corners are marked and have been marked by a survey company. What we want to do is put a fence there to protect her property rights, to protect our property rights, so that everybody knows clearly where the property line is. And I would agree with Trustee Johnson Burek that you do need to follow your ordinance. And I would just point out the bit that Eddie read, which is in the general provisions, which is 1860-220, that says, when the common boundary line separating two or more contiguous lots is covered or partially covered by a building, or when two or more such lots are used as a single building site, such lots are considered a single building site, and the yard spaces as required by this title then shall not apply to the common boundary line. Okay, that's in the general provisions. That's actually a historic preservation consideration, because they're trying not to affect existing zero lot line properties in the town of Mesilla. That's why it's there. It's in the general provisions, therefore it applies to the whole code, and we would just request that you follow the town code.
Question for the applicant, please.
Sure.
So why, and it could have been because we also had different staff,
Yes,
why that wasn't presented 4 years ago?
that's a great question. It was actually 5 years ago,
2021.
2020.
No, June 10th, 2021 is when we had the special meeting.
Okay, well, in
When
any,
you appealed.
it's been a long time in any case. I don't know. In my experience with other cases in the town of Mesilla, it's not always easy to read the town code as a whole. And you have to read it as a whole. You have to read the general provisions along with the code that's set forth in the different zoning sections. And we had a case a number of years ago that was problematic because the town had not read the general provision that was basically a grandfather clause. Not this one, it's a similar kind of thing. So it's easy to miss. I missed it. And after Eddie and I were talking about this again, I was literally sitting in bed one night and kind of sat straight up after accidentally reading this general provision. So
Thank you.
thanks.
Thank you. Any other questions, trustees?
Well, just a comment, I do want to be, very cautious that we do not start, the ordinance for the development standards for new fences is very, very clear. 18.35.060 letter D. I don't want to start bypassing this. Thankfully that we do have, I'm a little more comfortable with what was brought up to approving this, but I don't want this to start becoming the norm, that we continue not to follow, what the ordinances do call for.
And trustee, I think that just in noting on that, this is one of those unique properties, and we have several unique properties within the township. And I think that that's one thing that we should always be taking into consideration on a case-by-case basis, which is exactly what we're doing here. And how this was pointed out, it's especially with those sections that, or that section that does show kind of precedent, if you will, as well. So
Yeah. That's why
I think
I
it's
feel a little more comfortable.
it's one of those things on that. So, but I think duly noted that Mr. Salazar or Leona, when they receive these applications, looks into it and tries to provide the best information possible to everybody. Any other questions?
I do want to comment too. I do empathize with the property owners with how unfortunately, that property has been impacted. So, yeah.
Great.
That's all. Thank you.
Thank you very much. Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Nevada's for approval of PZHAC case 062009. And if there is no further discussion, Gloria, if you will roll call vote, please.
Mayor Pro Tem Merrick,
Yes.
Cadena,
Yes.
Trustee Johnson Burris,
Yes.
Trustee Nevares,
Yes.
Mayor, the roll call is 4 yes.
Great. Thank you very much for approval of PZHAC case 062009 for 2320 Calle de Santiago. Next item up for consideration and approval is approval of PZHAC case 062010 for 2488 Calle de Guadalupe submitted by Old Town Investments. Madeline's requesting approval to build a wall and fence on a commercial property in the historic commercial zone.
So moved.
Second.
Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Johnson Burek. We'll open it up for discussion. Eddie, if you'll just give a background, please.
Yes, this property is at 2488 Calle de Guadalupe. It was submitted by Old Town Investments, currently known as Madeline's. Requesting approval to build a wall fence on the property. The intent or the reason why they want to build this wall, and you can see a site plan of the area where the wall is going to go, and also a street view of where the wall is going to go, is that the business wants to serve alcohol outside on the patio area, and it's one of the requirements from New Mexico, our RLD alcohol division, is that it needs to be enclosed in order for them to do that. The wall is going to be just like the wall that's around there already on the north property line, so that it'll have it will comply with so it can comply with again New Mexico or the alcohol division. I stand by for any questions.
Trustees, any questions?
The addition is going to be the same height as one that was added in 2019, I guess.
Correct.
Yeah.
3 feet.
Any other questions? Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Johnson Burek. And if there are no other questions or comments, roll call vote, please. Gloria?
Trustee Nevares,
Yes.
Mayor Pro Tem Merrick,
Yes.
Johnson Burris,
Yes.
Trustee Cadena,
Yes.
Mayor, the roll call is 4 yes.
Great. Thank you very much for approval of PZHAC case 062010 for 2488 Calle de Guadalupe. Next item on the agenda is approval of PZHAC subdivision case 062018 for 3000 Snow Road submitted by Santana Ocoa, requesting approval to subdivide in order to install a manufactured home on the property in the RF zone.
So moved.
Second.
Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Nevades. I will open it up for discussion. Background, if you would, first, please, Eddie.
Yes, Mayor, trustees, it says case number 062018. The address is 3000 Snow Road, submitted by Mr. Santana, requesting approval to subdivide in order to install a manufactured home on the property. You know, again, this application or this request is only for the subdivision at this point. The reason why I put manufactured home is for, to show the intent, what they're trying to do with the property, why they want to add that subdivision. The very first comment I like to make is one that was made during public comment is, manufactured homes allowed by our code or not. That is one of the questions. There was a previous case that did come up. It's been a while back that I do remember, and I did looked up there is a New Mexico state statute regarding pre-manufactured homes that states that municipalities may not or cannot discriminate against manufactured homes due to anywhere a single-family home site build is allowed. Okay, so again, we need to kind of follow state statutes. I don't think that reflects in our code, but because of the state statute, I think that's should be considered. Going back again to the subdivision request, there was a subdivision request 2013. It states here on the board action form by Mr. Padilla on Fresquez Road. It was presented to the commission. At the time, the commission reviewed it and came up with a condition for approval that all the properties, all the parcels on Fresquez Road, on the north side of Fresquez Road, be recorded here in Mesilla. Currently, these parcels are 1 acre parcels. They do meet minimum standards for the zone, which is R1. So we're not asking, or the applicant is not asking that a variance of any sort or whatsoever. They're just trying to build a home or have a manufactured home on it, and they're trying to figure out a way how to go about it. Did a lot of extensive research on this case or on this request, along with MOI surveying. We looked at all the minutes, the numbers, the applications. There is a home already on Fresquez Road that was already built on 1 acre parcels. There is water, city water, fire hydrants. There are stub outs for each individual parcel on every parcel going down there, according to Public Works. If you look at the packet, also it is we're able to find that Mesilla did indeed approve the zoning to R1 on January 14, 1980. One of the things that I couldn't find is a subdivision shortly after it was approved. But the minutes here reflect throughout, it seems almost like a year, they were going back and forth. They'll reflect that the Board of Trustees and the Commission understood that the reason for going to R1 rezone was to make that northern part of Fresquez Road a 1 acre parcels throughout. So Mr. Fresquez was able to leave behind some property to his children and his family members. Again, 14 acres to their family members. So, the commission states, so their condition was go back, speak with all the owners on that side of the Fresquez Road, and have them submit a subdivision request application to follow the process that wasn't followed in the past. All right. I accepted that condition, or the applicant accepted that condition, but after reviewing with Mr. Moy Surveying and the county, there's some property laws outside of municipal code that are concerned that I don't think we're able to meet that condition. And I believe Mr. Anton here would explain that a little bit better than I can. I'm not 100% familiar with property laws as he is. Also, I'd like to kind of point out that in our Title 17 in our code, our subdivision code that regulates our subdivision, it states that the town adopted a subdivision, that subdivision ordinance in 1989. So we did a lot of work looking at what's going on when got passed when it comes to subdivisions. The county at the time was accepting these requests from property owners to subdivide without conforming or communicating to the town of Mesilla as they are today. And I feel a lot of the times that back then with a lot of these property owners wanted to leave their lands or parts of their lands to their family members. They didn't know. They didn't know the uneducated Spanish speakers, those kinds of things. They would go to the county. The county went ahead and recorded the parcel, and they thought they were done. We have here now the new property owners wanting to do something that the property was left from their grandparents, and now they find out that they can't. Right. So I'm not asking for, applicants, and I'm not asking for bending any rules. Again, that's just this stage. What do we do? What do we do? How do we go about allowing or being able to use or this side of the road, or giving the property owners that right to make use of their property? So we talked about it extensively with the commission. We had a work session with the P&Z. And the outcome of all ins and outs was that they recommended to accept the parcels as they are recorded currently at the Doña Ana County office as they are now, and record those here in Mesilla because, again, the condition that they had set, and again, with Mr. Anton, we'll do a little bit more explaining. It's a little bit more complicated than just what the code states. And at this point, I'd like to invite him over, and he can explain the other half of being able to meet that condition that was set. So, Mr. Anton.
There's a lot going on there, so bear with me. Take it step by step. My name is Anton Magallanes. I'm with Moy Surveying here in Mesilla. Good evening, trustees, Mr. Mayor. The biggest question that I think we probably as the town has to determine, the biggest question that we have to answer rather is, at what year does our subdivision regulations come into effect that therefore anybody who wants to subdivide land would be required to as of what day? That's the $1 million question I think we're trying to find the answer to. And I appreciate Gloria, Liana, and Eddie for letting me read through the minute books. They've been super helpful. Eddie mentioned the county. So I've talked about this a little bit before previous meetings, but if I had a piece of land and the year was 1980 and I had 2 acres and I wanted to give my mom 1 acre, I'd hire a surveying company. They'd prepare 2 legal descriptions. I would just go to the clerk's office, record it, and the county would accept that as 2 legal lots. They say, okay, cool, 2 legal lots. We were able to do that via that process up until 1996 with the county. At 1996, they developed subdivision regulations that no longer allowed that to happen. Now, if I want to give mom 1 acre from my 2, I have to go through a subdivision process or some type of split process, but I can't just record a deed with a legal description. So our question started to say, our initial question is, what is the year that the subdivision regulations got enacted for Mesilla? And that's a lot harder to answer. We know that when Eddie mentioned that the county was accepting some subdivisions, so from the town of Mesilla, the family behind me went through the due diligence of rezoning the property to R1. Then the next question would have been, what would have been the process in about 1980, because that's about the time that they started subdividing or giving the land to their family members, what would have been the process for them to do that with the town of Mesilla? Was it just hire a surveyor, write a legal description, and go record it, which is what happened? Or was there a subdivision process that the town had in place, aka our subdivision regulations? So from what I can gather, they did go and just record deeds. Now, the clerk just said, okay, we'll make the changes on our map, and now the county parcel map reflects what is the underlying of the map you see there. So in front of you, you have what is an old survey from Gilbert Chavez that has, I think, 14 little individual 1 acre pieces. And so that is what they look like according to the county records. If we pulled up the county parcel map, that's what those look like today. That's not what the town of Mesilla is accepted though. So we have the county parcel map that reflects 14 1 little acre pieces, but the town of Mesilla has it in what is the pink, yellow, and pink. So a 5 acre piece owned by Rudy on the left-hand side of the paper. They have Elisario owning 4 acres in the middle with yellow. And then they have Juan Padilla owning 5 acres on the right side of the paper with pink. Is that making sense? Are you following me with that so far? Okay. So the town of Mesilla sees it as a 4 acre, 5 acre, 4 and 5 acre piece, while the tax assessment is 14 1 acre pieces. So we already have some conflict there, but that's okay. The biggest question is asking, when does our subdivision regulation start so that we could say this was the process at this time? I read the meeting notes from 1972 when the Planning and Zoning Commission recommended approval for a zoning ordinance. They recommended approval for a land use map, and then they recommended approval for a subdivision regulation. So at that meeting in February 15, 1972, was planning and zoning, but there were some trustees here. And according to the minutes, it said, the trustees said, we better call a meeting tomorrow because we don't have enough trustees here today to make a quorum. So then a special meeting was held on the 16th for the trustees. And at that meeting, they accepted the zoning ordinance, they accepted the land use map, and some subdivision regulation. So the biggest thing is, what's that subdivision regulation? And we scoured through probably 30 years of ordinances, 30 years of resolutions to find anything that said subdivision regulations at that time in 1972, but we came up empty. The only ordinance we can find so far is 89001, which is the ordinance that basically establishes our subdivision regulations according to our code today. So when we read our code, and I'm specifically looking at the subdivision portion of our code, it says under authority, the land subdivision regulations are authorized by Articles 19 and 20 of New Mexico statutes, approved by the Planning and Zoning Commission at a public hearing on the day of, and adopted by Ordinance 8901. So the authority, according to our code, is also coming from 8901. So it seems like those two jive, at least that maybe that golden year, that special magical number that I'm looking for is 1989, because that is when the ordinance came into play. Why that matters is because the applicant went through the subdivision process as required to, because we probably already had a zoning ordinance, but then hired a surveyor and recorded all of those legal descriptions that created 14 1 acre lots. But in 1980, I would say we didn't have subdivision regulations that I think Eddie would agree that we can find via an ordinance or resolution. It wasn't until 1989 that said, this is the process to subdivide land. So had they waited until 1990 to try and do that, they would have had to subdivide. But what I really believe the motion is asking, or one of the options here tonight, is to accept these 1 acres as they already are deeded out by the town of Mesilla and just have them accepted as their own parcels and acknowledged individually. And our basis for that is that we didn't have a subdivision regulation come into effect until Ordinance 89, while all of these legal descriptions were already recorded prior to that date. That also, I think, helps in different situations where we have a 2 acre piece of property in the correct zone, R1, and someone says, hey, I want to build a house on 1 acre and give one to my cousin, whatever. Now we can easily say, are these legally 2 1 acre pieces before 1989 via a legal description that was recorded, or was it 1? And so 1989 becomes this really easy number for the town of Mesilla to then just establish as this is the day that we have to move forward from. To explain just a brief little bit about, again, a little bit more about that map in front of you. So if we ignore all of the color, the underlying parcels are what is viewed by the county as their individual parcels. The pink on the left side, again, is the 5 acres that Rudy owns, 4 acres that Elisario is in yellow, and then we have 5 acres again that Richard owns in pink. The problem with that is that because the assessor has each individual parcel parceled out, there's been conveyances of those 1 acre lots back and forth to people already. So Rudy on the left, Elisario in the middle, and Juan on the right are no longer the current owners of the combined 14 acres. We have Rudy owning some, Felicia owning some, They own some. We have Richard owning. So it's not as simple as down into 14 1-acre lots. People, multiple parties owning what is the combined 14 acres, only because you guys aren't involved in that sale process. So when that piece of property sells, the title company can close it, the clerk lets it get recorded, but you guys saw this as not really its own legal lot, and the only way it ever comes into question is when a building permit's required, which is where we are today. So for instance, if Felicia wanted to sell me a lot, she could sell me a lot. I can go get financing for it. The title company will close it. The clerk will accept it. It'll change ownership. But then when I come to get a building permit, they're going to say, oh, this isn't really a legal 1-acre lot. That happens. It's not uncommon. I've had to fix those problems before. But again, until we really understand that 1989 subdivision regulation rule, we're not going to know when we have to start abiding by what the regulations were. We're willing to do so, but what is that date? And so with everything here tonight, I think we are asking the town of Mesilla, we did ask the P&Z to accept these lots as they are and work towards establishing 1989 as the beginning of our subdivision regulations moving forward for the town. Be happy to answer any questions or clarify anything. Of course, I know it's a lot of information. Yes, sir.
I tried to follow what you said.
I was like, I hope that doesn't happen. I know.
But you're saying the county has these as 14 separate lots.
Mhm.
But what's before us today is to subdivide one of the lots or the entire parcel. That's one question.
So what's before you today is, the board has the option of saying, how do we resolve the issue? Because again, according to town of Mesilla perspective, we have 3 pieces. We have the pink, the yellow, and the pink. And that's what's highlighted there. But we know that those aren't just the 3 owners. So the ask, if you will, is to say, will the town of Mesilla accept the 1980 recordings of all those individual parcels as legal lots so that they can build, continue to convey and sell as individual pieces without having to go through the subdivision regulation? Because I can't justify what the subdivision regulations were in 1980. We know that's of 1989, but what happened before that? How did people subdivide land?
So, but it's still, I guess my question is, the question before us is this one property owned by Mr. Ochoa, right?
I don't know if you can make that decision with just the one without having to consider all
This is
14.
not what's written in our paperwork here, as I see it, that, it makes it problematic because it's referring to one person, not 14 individuals.
Gotcha.
I mean, if it had been worded that way, then what would be before us, what you're asking, is to subdivide it into, recognize the 14 different lots. But that's not in any
Sure.
of the documentation.
And I understand that. I guess then to satisfy that, we would say to accept Felicia's lots as they are, which is gonna then establish the others to be established as well. There's like a fundamental question to say, when does the town of Mesilla acknowledge that there's a subdivision process? And until we understand what that date really is, it makes it really challenging to say that somebody was forced to do a specific process at a time. To answer your question specifically, we can look at these 2 and just say, can these 2 be accepted as they are? Sure, it's okay. It just keep in mind what that does for the other properties is allow them to then stake the same claim.
I'm kind of following the paper trail that it says in the.
Sure, absolutely.
And the other question I have is, this came before the Planning and Zoning Commission. Is that what they heard? Is that what they decided?
That is correct. Trustee Nevares, Eddie Salazar. We did have a work session. We did talk about it extensively. We discussed a lot of options. A lot of them kind of led to a dead end. Most of them led to a dead end. And I think the best ones that the commission decided was, again, to accept the lots as they are.
The 14 lots.
Correct.
I know, but why is it not anywhere in the documentation that this is, I mean.
Say that again, I'm sorry.
It's for one lot.
Uh-huh.
Okay. And I can see that in the paperwork, but what I am understanding is, I'm hearing this evening is that we approve 14 separate lots, but that's not what's in here.
Well, the applicant is looking to build a home, so the initial request is for their lots themselves. But after discussing it with the planning and zoning, again, because they felt that the rest of those properties are probably going to follow suit shortly after, and to save, the time and pretty much to save the time and set, because that precedent's already set, the decision was made to accept the rest of them as well.
I understand what everybody's saying, but if the paperwork before us had said we request to have these 14 lots recognized as separate lots, I would have no questions that I'm questioning here. It's nowhere here that we're being asked to do this. We're looking at what's before us, and it says administrative approval is one lot here.
Yeah, the property owner, the applicant
Unless you could
owns.
show me where it says
Real quick though, just to follow up on that, just as a question, and it's a generalized question to you, trustee, as well as to staff, is that as it's been presented here with being recognized as 14 separate lots by the county, but all separate owners, how would that be? Who would be the ultimate applicant that would be submitting the application for 14 separate lots to be recognized? Just for clarification. And I think that's what we're trying to decipher and figure out. And I know that in the way that it's presented, I understand what you're saying. I just, for clarification and recognition of the way that it is, how would that be presented?
So is there an answer to that?
I would only state that during the work session meeting, planning and zoning was concerned that they didn't want somebody else who happened to be not one of Felicia's 2 lots, right, another 1 acre lot, to have to go through the same problem. And so they said, are they going to run into hiccups if the process changes, or are they going to? And so therefore they were looking at it holistically. The other thing that gets really challenging is that, yes, it's the subdivision process, right? Because there are some people, and we have not spoken with Mr. Abrams, who is a trustee of the home that is there built in the middle. However, he may not have any consideration or desire to do so. He has a nice home that has its addition, that has a mortgage, let's assume, over a piece of property that he may not want to say, oh, I'm going to turn around and request a subdivision process. The town of Mesilla issued him a building permit on his acre pieces already previously. Point being is that the coordination of the people who are now vested owners of these lands may or may not want to or have accessibility to apply. One of the recommendations, or one of the questions rather, from the work session is, do we need every person to come in and sign something authorizing that they're okay with this, right? Like everyone who has a vested owner. And I believe the applicant had reached out. I don't believe that they had actually communicated with Mr. Abrams. But the concern with that is that if one person said, well, I don't really need to do this, why am I going to? Does it then not allow everybody else to also? But I totally do recognize your question. And I think, to be specific, I don't think that it's saying 1 lot or 2 lots. I think it's just saying for the applicants to subdivide her piece. It's referencing an address. So if the board did feel more comfortable saying, we will acknowledge that her 2 pieces, being what makes up 3000 Snow Road, are accepted by the town, then each homeowner or lot at that time might then have to come and do this process.
Yeah, I think
Sure.
the wording in this document is that piece that you just stated.
Right.
Not the 14, but
Yeah. Right. And I think, I think we talked about it via the work session being it's a holistic approach, because we're going to have this conversation 6 times.
But I have a
But-
difficult time putting my hands
Absolutely.
around the holistic approach, because it's nowhere documented that this is what's being
Sure.
requested.
Well, I would also recommend that we could, the board has the ability to make a motion to amend any of these cases as they probably were presented, right? Like,
Yes.
we can amend them with conditions. We can work to approve them with conditions if we chose. But again, given that we have the applicant requesting their piece, I don't think there'd be any issue with those two pieces being accepted
I
only
don't see
and
any
not
issue
excluded.
there because that's what's in here.
Yeah, I understand. That makes sense. It's following.
Yes.
Yeah,
yes.
100%.
I'm pretty stickler with the work I do outside of this
Sure.
realm is to have documentation as to why you make this decision. I don't know how the other trustees feel about it, but I would feel better. The other thing that I think was confusing is when they added in order to install a manufactured home, because that's a separate process.
Sure.
So, you know,
I think, and again, chime in, my only perspective is normally there's just context provided around what we're doing. And I think that was just the context. But yes, this does not mean that a mobile home can go in there, a manufactured home can go in there without a permit. You're not authorizing or granting a permit. It's just saying to be able to, they could have very well, the town could have said to be able to build a home or
Yes,
to be able to
something to
provide a
clarify that.
residence. Sure.
Okay.
Yeah, I agree with that.
I feel comfortable looking at what's before us in the subdivision.
Sure.
I mean, it's got a lot of history and everything, but to say it's for 14, I mean, nowhere does it state anywhere.
Sure.
About that. So I just, for the time being, I'll see if any other comments from the trustees.
Mayor, trustees, yeah, that's one of the reasons, the last comment that I made there on departmental comments is, that is the best planning and zoning after discussion was considering. But yeah, obviously, they knew that, upon presenting it to the board of trustees that, your ideas and recommendations are also welcomed to be able to allow this property to be, subdivided as it's currently recorded.
So do we need an amendment just to approve this piece? Because that's the only one before us, and this is the one I'm willing to consider. I mean, personally willing to look at, not the other items that has been discussed as a whole package, a holistic package.
Sure.
I just don't see that right now.
Okay.
But looking at what this the applicant is looking for, I mean, it's something that we can consider. I mean, yeah.
Okay.
And so I know now I understand the history a lot better. I understand that what occurred in the past. So with that in mind, I mean that's the way I'd look at it.
So I think we were just getting confused because during the process of discussion, they were talking about the 14 lots and looking that in the future. So it's not something that they wanted us to approve. It's just something that they wanted us to consider and look at in the future, just to clarify.
Correct.
So the only thing we're looking at right now is the subdivision and the manufactured home.
Exactly, 100%.
Thank you.
And I apologize if I
Not
looked at
just
it.
the subdivision
Yeah.
to potentially build a manufactured home.
Right.
Yes. What was confusing is when bringing up the verbiage about the 14. No.
Okay. My apologies. Sure.
So I apologize for my confusion.
No, it's good.
Because that's the way I heard it presented. So.
Okay, Mr. Mayor?
Trustee.
Okay. Well, I mean, I am very sympathetic to the families that own this property and how it was subdivided in 1979 or whenever it was. However, I mean, 1989, 1970 seems like a long way away for some people. I mean, way back there, but it doesn't to me that much. What I don't like about your premise is that everything prior to 1989 would be considered somewhat out of this subdivision recognition at this point with RF zones. So there is no way that I feel that anything prior to 1989 that was recorded at the county but not recorded with us should then be reconsidered to follow the county. There are properties all over Mesilla that have filed incorrectly with the county at many times. And if we were to do that, there would be, I mean, I don't mind considering this on some other premise, but not on the premise that we are going to go back and say that because this property was subdivided in 14 different ways in 1972, or I'm sorry,
Yeah, no,
year,
that's okay.
but 1980, and we didn't have a quote subdivision law till 1989, so therefore we go with the county. I don't buy that.
Yeah.
Because we will get in a
Sure.
deep hole in this town because there are so many properties that are listed incorrectly at the county. And so people that have bought places thinking that they're in RF or RA or even R1 zones, and that's the way they were at the county. Mesilla has other
Sure.
things. So I don't know. I mean, I feel for them. I do, and I'm not sure. I mean,
There could be legal implications.
I do too. I just think we gotta, I mean, like I say, I feel for the families. I do. And I mean, I mean, a lot of families have that same issue that would like to subdivide their property, and we've not let them. And I totally respect Mr. Gatto's point that we lose families because they
Sure.
can't build, and then somebody else comes in and gets approved. I have committed to try not to do that, because that's the last thing we want to do for the people in Mesilla and the old families like the Fresqueses, for sure. So I'm not totally comfortable with how this is going. I mean, at right now, I would just have to vote no on that premise alone. I mean, not even, and I read the minutes in 1989,
Yeah.
all this stuff. And I appreciate that you scoured everything to find the subdivision law and all that. But I also know that prior to 1989, if we were to say prior to 1989, if you filed with the county, you're in, we're going to be up without a paddle. So, I mean, that is my knowledge of the history of Mesilla and the things that we have faced over the years prior to 1989, which, Mr. Cotto might know about, and myself and Ms. Kruger, because we're old in a good way, but still.
Institutional knowledge is what they call that. Yeah.
But so that's just my view on this itself. I mean, I feel for them. I don't have a problem. I just think,
Mr. Mayor, Trustee Kalina, may I ask, so when would you say that the subdivision rules applied? Because I mentioned the 96 rule only as an example that every municipality has this rule, like the counties is, as an example, 96. So we know that, I think Mesilla got incorporated in 50s, 54, 53, something like that. So how did people subdivide land before Mesilla was a town? And in the 50s, we didn't have a subdivision regulation, so were people not allowed to, or what was the process? So at some point in time, we have to say, here is the date that the rules start. And I respect the position, because it is a tough one. I knew planning and zoning couldn't make that decision alone. My question is, what's the date?
well, I mean, if you want to use this as a test case, we can, but I don't feel comfortable
Sure,
about
absolutely.
deciding that right now.
Mhm.
I mean, I think there'd have to be a lot more research by the staff and maybe others, the committee possibly, to look at that and see now that it's come up, and it's critical. I mean, for this family, it's
Sure.
critical. I know that it's been critical for other families too,
Mhm.
in the past that have been refused. So I can't
Absolutely.
answer that question either.
Sure.
I don't think this case has enough information in it, and I appreciate all the research and everything that was done, but I don't feel comfortable going forward with it.
I guess the paperwork also has that in the RF zone, and that's not correct.
That's incorrect.
Right? So it's R1 and 1 acre tracts are allowed in that zone,
Yes, sir.
and you can build on 1 acre tracts. I'm trying to figure out, because the history shows there's a dilemma here.
Yeah.
And it's not of the making of one person. It's just the way things were. I
Sure.
guess. So I'm looking at the date that you have to set a demarcation, I guess, and that was 1980.
89. That's the 1989 is resolution 89001, which repealed any previous land regulation and established what our code says today. So then likely I said, okay, well, what was anything prior to that? But no resolution or ordinance was
So you're
found.
putting that forward because it would be defensible if you make decisions under this premise.
I think I recognize the legal implication there may or may be on both sides of the aisle in
Yes,
this, because
but if you use this date, because there is a date, a firm date as to when this was.
at least a firm resolution number, again, which is stated in our development code for our subdivision regulations. It says per ordinance 89001. So,
It's just
but yeah.
difficult to hold this in limbo like in
I know.
perpetuity. There has to
But
be a
this
decision.
is RF. It is right now RF.
No, ma'am, it is R1.
R1.
So it did go through a rezone. And to make matters worse, we have a zoning ordinance and then we have a subdivision regulation. Those two things interact independently. I do recognize it may state in the packet RF. This property, yeah, this property did go through a rezone and was successful to R1. So if we look at our zoning map, it's the only strip of R1 that's there. And they were successful with that and they got it rezoned as R1. So yeah, on a zoning perspective, there is no implication with what we're requesting that has any impact on zoning.
So-
But I recognize the,
But the
inaccuracy.
paperwork said RF.
Sure.
So I think I would feel comfortable if we had an amendment saying this is for the
So-
record that, this is an R1 property that allows, for this.
Well, is that hold on one second. So is that a formal motion? to
This is
amend?
a formal motion to amend, to recognize this is an R1 property.
Second.
Okay, so a motion on the floor to amend to recognize as R1 property. Motion on the floor by Trustee Nevadas, seconded by Mayor Pro Tem Merrick. Now we'll open that up for discussion before we go back to the original motion.
Okay, so why in the paperwork does it say RF? I mean, I tried to look at the map and, because I'm in the same dilemma.
Sure.
I mean, why is that even,
That
why is there any confusion there? Why would it not say this is a weird parcel, it was approved?
if you look, and I do apologize, it does, that's my mistake, to have put zone rural farm. But that is why whenever I submitted the minutes to this packet, and also I got some references here also that we have many confirming lots in Mesilla. This property, along with the rest of Frescas Roads, meets minimum standards of 1 acre. I am not able to find records of subdivision properties or as of that. So yeah, I do recognize that the original or the top one item, subdivision 062018, it does state rural farm, but again, that is my mistake in my sense. But this stretch of Frescas Road has already been rezoned R1 with the properties parcels already at 1 acre parcels. And that is why, again, the commission decided to record the parcels as they are now because they do meet the minimum conforming to R1. They did get rezoned approved. It's the only thing is there's no record stating that it went through the process of being subdivided.
Okay, do you know when this yellow, pink thing happened where there was only 3 owners and they were subdivided like that to reflect actual RF zone?
Yes, the rural, there are minutes right here. I believe I did, let me pull them up. I did highlight it on the sheet, but it was on January 14, 1980 is when the commission or the board of trustees made a motion and it carried to rezone from RF to R1.
Okay, but does not reflect on
Correct,
this.
correct.
So when this is what Mesilla has recorded for this property.
No, that is what the county has recorded with the property.
The 14 plots is
Correct.
what's recorded at the county, the pink, yellow, pink is what we recognize.
No.
Yeah, whenever,
Yeah. So that she is,
Unless they are changing it,
So-
I'm not hearing things.
yeah, and Mr. Mayor, trustee, yes, so when the applicant came in to apply for a building permit, they stated that it was do you have that exhibit with you? The 454? That it was the pink, yellow, pink, that right now, although the county has it assessed as 14 individual lots, and there are legal descriptions that are on record from 1980 for those, in the perspective of the town of Mesilla, it is a 5-acre piece, a 4-acre piece, and a 5-acre piece. And so the pink, yellow, pink is the perspective of what the town of Mesilla has for legal lots. Now, we know that they'd be eligible to subdivide down because it is an R1 zone, so they could, right? They already had the process of subdividing done before, but through the lens of the town of Mesilla, it's a 5-4-5, the pink, yellow, pink, which is consistent with Trustee Cadena. And so that then triggers where we're at today because our applicant owns 2 acres of what is the yellow piece of property. Or I think she owns 1 acre from the yellow and 1 acre from the pink. And Mr. Abrams, who was granted a building permit because I think the town of Mesilla thought he owned what was the original 4, didn't own that yellow 4. He owned 3 from the yellow and 1 from the pink. So that's where there's some challenges there.
When was that approved, the Abrams?
I think that was just via legal description because there wasn't a subdivision that was done for that. And those records predate 1980 because there would be legal descriptions describing a 5, 4, and 5.
So just real quick, if we pull up these properties on the county parcel map, because you can drive down on the specifics on that, on who owned the property, when they owned it, when they built, so on and so forth. So we can see that back in 2001, specifically for the property that Matt Abrams owns right now, or Mr. Abrams, that has those 4 properties. He didn't own it then. It was owned by this shows Patricia Carrillo in 2001, and then John Smith owned it in 2003. So with that, I'll also note that the house straddles, that's on that specific property, straddles over the yellow and the pink, as
Right.
we just noted. So that was approved back in 2001 by whoever the commission was, the board of trustees. That's that. So we've been dealing with this issue since that point in time as well.
Right.
And it was recognized. Here's the other question that I have, just in general, is because I noticed it's in the notes. And when we did a water loop in the town a couple of years ago and looping all the system, we went ahead and put the water infrastructure down this property and looped it, or down this line, down this road, Frescus Road, looped it all the way down and looped it back up into all of that, putting fire hydrants and everything else into that. So in technicality, if we're putting in that infrastructure as the town, are we not recognizing that it is a subdivision? Are we? And I'm just asking questions.
Yeah.
And then
no,
if we're putting,
two
if we're
mistakes don't make, 2 errors don't make a
right,
make
but
it right.
this was done in recent years.
I know.
And then we also have
That's what I'm saying. is-
water outlets that were put in at 1 acre intervals in plans for water meters to be put in as well. So I'm just,
I read that, and I mean, that did puzzle me.
and just to your point, the 2 wrongs don't make a right or anything to that extent, but it's like we've recognized it, but we're not recognizing it. But we're kind of beating around the bush to fix the issue, which.
Well, I don't agree with that premise either, that we're beating around the bush. We're just trying to understand at this point in time, because all of us have a different understanding of this particular situation, and it is going to come up again because there's more properties and people may want to build or tear down or whatever they want, or subdivide again for the people that do own 3 or 4 acres. So I'm just trying to wrap my head around it because it did look like it was zoned RF, and that if we're recognizing it, and it would make sense that we would state an RF when the pink, yellow, pink is at play. When the R1 happened,
But
We
even if,
didn't recognize that as the town of Mesilla.
You recognized R1 being approved, so that zone did get applied to those pieces of land. The next subsequent question, people get this confused quite often, is now that you have the ability to size down your parcel from 5 to 1, what is the process to do so? Because the zoning doesn't automatically do it by itself. And yeah.
So that's where the subdivision rules come in, and that's where we were trying to apply. I mean, you were trying to apply for subdivision, but in fact, they were advised not to really do that because they'd have to redo the whole. Because what would be the process to say that you wanted to make the 14? We don't know how many. Do we even know how many properties are actually who's what, when?
So the color coding is the best that I could do at this point, besides doing like a full title search.
She owns 2 acres. Is she gonna build a manufactured home on both the acres? Is she saving the 1 acre for the
Right.
next kid? I mean, and it's none of our business
Sure.
necessarily, but we're trying to leave the best footprint for future decisions
Sure.
regarding this piece of property and any other piece of property that comes up. And for me, that it's already in R1, that, I mean, we got to fix this whole thing, and we have to be very specific about this piece of property because it is kind of an outlier anyway, with an R1 zone in the middle of an RF zone.
so we have motion on the floor for amendment for R1
Mhm.
recognition in this case before we continue on. The only question as far as that I have that pertains to that is that the property or properties in question, as they are at least a minimum of 1 acre in size, presently abutting another property that is existing, not creating another non-conforming lot potential.
So at this point in time, we haven't surveyed all 14 lots to confirm, but based on the subdivision plat that Gilbert Chavez did, which was also based on subsequent survey information as stated on his plat, he's showing them as 1 acre. So I suspect with best judgment possible that yes, the intent is to have those all as 1 acre, and there shouldn't be any lots that are less than what is the minimum R1 requirement.
So the lots that are here that we're looking at that have been submitted by Santana Ocoa are 2 acres or more in size,
Yes.
subdivided into potentially 1 acre parcels.
And then, yes, it would just be, is it 2 of a larger 5 piece? So are we subdividing 2 out of the pink 5? Or are we accepting her 2 1 acre pieces as individual lots? Or what would be that process so that she's eligible to grant a building permit, I think is the fundamental question.
That's, if I may, Mary, that's the original condition that the P&Z on 2023 wanted. And also, when we reviewed it here this last meeting, same thing. We want, ideally will be go and do the subdivision so we can review it and get it approved. But as you just listened from Mr. Anton, being able to do that legally with property laws, it's a little bit more complicated than just saying go subdivide it. So again, the commission, myself, we're open to suggestions or ideas to how do we get this. It's already R1. It's already been subdivided, right? It's just a matter of how do we accept or how do we put conditions on to fix the problem that we have at hand. And we weren't able to find any during our work session and also the discussion, the regular meeting. And the best decision that we came up with, again, was to accept the parcels as they are now.
And that's not as they are now in Mesilla, but as they are have been done
Correct.
by the county.
County.
So that's even kind of misleading. It's not as if they are now, it's how they're recognized by the county.
Wait, you just said not that we have to recognize the parcels as they are now. Isn't that what you just said? Because here it says, according to Anton, from Moy survey, you can't just record the parcels as they are now.
Correct. Yeah, so,
So that was a contradiction.
well, no, he's saying that, I mean, the board, so the board has the authority to accept these lots as the county is assessing tax on them, just because you're right, like, yeah, to be very clear, the board has the authority to accept these lots as 1 acre lots. And I'm not a professional on what the board has authority to do or not, so please take that lightly, and no offense, of course. They could accept them to say, yes, we recognize that there was or was not a subdivision regulation before this time, therefore this would have been the process to subdivide land. Today, thank God, it's a very different process that you could not do what was done then to a land. So I can't take my 5 acres in Mesilla and just go record that, because it'll get recorded, but the assessor will kick it back and call it an illegal subdivision because we don't have authority from the town of Mesilla. But it seems as though that wasn't the case in the 80s, because they made that determination to assess tax as such. So again, like, I'd love to say this is extremely uncommon, but it's not. People back in the day would split up their 10-acre farm and say, I'm going to go to the assessor and get 2 account numbers. I want my house zoned for residential assessment, and I want my 9 acre zone for agriculture. So now they have 2 account numbers, but that's just for tax purpose. So everybody now thinks that it's 2 legal pieces, but it's really just for tax assessment. But then what starts to happen, somewhere down the road, somebody sells the 1 acre, and it was never legally subdivided. So it's really still the whole 10, it was just assessed 2 different account numbers. So the parcel map, and according to the county, it looks like 2, but it was only for tax purposes. And we find ourselves in these situations where we have what's an illegal subdivision that's been conveyed so many times.
Right, but the opposite can happen too, is that you have property, you add property to your property.
Mhm. Oh, yeah.
The county doesn't record that, and it looks like 2 separate properties. But for us, if you're RA or RF and you have 2 acres and add 3 acres because you got lucky and somebody sold
Yeah.
it to you, right? Or another acre or whatever, just to add more property to your property, that doesn't mean you have 2 parcels, even
Yes, it
though
does
that-
actually still. So
Well,
they don't
yeah,
allow
but-
merging or splitting property without the authorization of the body. So if I had a 2 acre piece and I was like, can you give me 3 so I can now have 5? I would survey that. Any surveyor should survey it as a 2 and a 3 acre piece. Now, if the town lets me build on my now what is 5 acre tract, cool. But legally, it's still a 2 acre and a 3 acre piece because there wasn't a process
I
done
know,
to
but
remove
with
that.
our law, with our saying, okay, you might have been zoned RF with a 2 acre plot because you were grandfathered in, 45 years ago or 50 years ago, or
Sure.
I
Yeah.
gotta go back further because we're already there almost. Then you buy the 3 acres and we say, okay, you're at the minimum 5 acres. You can't sell that property now as 2 pieces because now you've joined your properties, and that is now recognized as 1 property in the town of Mesilla per ordinance.
Sure. But legally, there's still a foundation for this property that says it's 2. That's what I'm stating, is that, like, I recognize that I just have to talk on the terms of a legal boundary. And so if the town says, yeah, a 3 acre piece and a 2 acre piece is now a 5 acre piece, and they decide they want to let somebody build across the property line, that's up to the town. You're technically violating setback, but if the town's okay with that, so be it. What normally happens is they say, hey, we need to combine those 2 pieces. Because if they try and, just like Mr. Abrams did, build across a property line, he's technically in violation of a setback. And some municipalities are very strict on that and do not allow that to happen. But sure, I mean, it's,
Mayor,
Trustee.
I'm just not comfortable with an argument being conditions set by commission in 2023 not realistic to be able to defend this. Again, I know it's just your determination
Sure.
notes. What about getting legal opinion? Just throwing it out there.
So that's a possibility, but there is motion on the floor. So then we can,
Right.
so that's the other side of that. So
Okay.
we can, but that the other process. So let's go back to the
Motion.
amendment motion on the floor to amend the original motion to recognize R1 zone for the properties. And just to add sorry, go ahead. Motion on the floor by Trustee Nevadas that was seconded by Mayor Pro Tem Merrick. Any other discussion on that amendment? I do want to, just for discussion and for clarification in county records, and pulling up just so that we have those two specific properties that are noted in line, is account number RO 400095, parcel number 40051383204070, and then the second is account number R0 400091, parcel number 40051383104070. I just pulled those up off of the map, county parcel map. So for the record,
Which ones are they? I don't,
they're the two that abut the yellow here.
right here.
So one red, one yellow.
One red, one yellow right here,
Correct.
which is helpful.
Which is the ones that he has slashed here on this side.
Well, I
Right
see
there.
that.
Yeah, so the hatch is what best represents what is owned by those people. So the change in the direction of the hatch is like, Fresquez owns now the 2 and then Abrams owns the 4. It's the only way that I could really overlay it to show what is owned by current owners relative to what the perspective of the county sees the 545.
Perspective of Lucia.
I mean, excuse me. Yeah, that's what I really meant. The perspective of Mesilla for 545 with also the tax assessment for each one. Yeah.
So in other words, Rudy owns now the ones with the green slashes.
Correct.
Correct.
Rudy would own.
Ms. Fresquez, or where the two that we're talking about today are owned by the same owner. The next 3 plus the first pink one is owned by Abrams. And then the last 1, 2, 3, oh no, then there's 2 owned by a person named Richard, is that right?
Yes.
And then 1 is on the end.
But I think that's Mr. Padilla's property today, if I'm not mistaken, that's the one. And then, yes, the last property in the end was not included in this, luckily. That was not a part of this original 14-acre piece. But yeah, that's what the representation looks like today. There was some question and of course some consideration that the applicant wanted, which was, well, how come we let Mr. Abrams build on his property when he didn't have it subdivided, and how come I'm not issued a building permit? I always explain, just because somebody else did doesn't mean you can't. Everything's case by case. However, we do ask for consistency. Using my just best judgment, I think that the town of Mesilla probably thought Abrams was all of the yellow, which would have been a 4-acre piece, which is why they said, okay, cool, you have this 4-acre piece. We don't acknowledge it as 4 1-acres. We acknowledge it as 1 4-acre piece. We'll issue you a building permit. But in fact, he owned 3 from one and 1 from the other. But this level of detail probably wasn't given then.
But you're also saying Mr. Abrams on that, but that was Mr. Smith.
Pardon me. Mr. Smith was the builder of the home. Abrams acquired the property. Yes. Mm-hmm.
All right, back to the original motion on the floor. Any other discussion on the amended motion? Gloria, if you'll roll call on the amended motion, please.
Nevadas.
Yes.
Bureau.
Yes.
Cadena.
Yes.
Yes. Yes.
Mayor, roll call for you.
Great. Thank you for that approval of the amendment to recognize R1 zoning. Now back to the original motion on the floor. So the other discussion.
So, I mean,
Go ahead. No.
Mhm.
Go right ahead. Go right ahead.
so for clarification purposes, I agree with Jerry over here that we have got to only deal with what's on in this situation, those 2 acres, right? We can't have anything else because none of that has been discussed here. I mean, is on paper. We just discussed it. So, I mean, so somehow that needs to be stated. And that is what's on the paperwork. And now it's R1. And is that all that your presentation is?
Yeah, I mean, again, I think at the end of the day, and I don't want to speak on behalf of the applicant, but I think she's looking for a building permit. Is that correct? So I think our means to an end are saying, how do we do that if the county just doesn't acknowledge this as its own piece of property? And I respect the amendment to R1, of course, and then recognizing only these 2 lots.
However, okay, but then how does that fit into our subdivision? Why wouldn't we just do what we did for Abrams and give them a building permit when it came up? I mean, why are we in a position to do this? I mean, I'm
Sure.
sure because we're really not looking at the whole subdivision right now. And you're saying to us that's not a very practical response, right? That's not a very practical ask to make the whole thing a subdivision.
It comes down to the servability of the code and relative to when we say we have the subdivision regulation. That's really what it is, because we know we have the town being incorporated at a certain date, and what was the process for somebody to subdivide land up to a certain point. And I recognize that's a hard, we're looking at information that we provided, but the reality is that, let's even just temporarily say that 1989 was the date that we acknowledged subdivision regulation for the town of Mesilla. That then does mean that if anybody has a lot that meets the zoning ordinance, of course, is eligible to build, even if it came from a bigger piece, because what was their process to subdivide that at that time? Because what the overstep I think that I'm a little concerned with is if we say we're not going to allow somebody to subdivide their land prior to a certain date. But I'm like, if we didn't have rules in place to say this is what that process is, how can we enforce what wasn't there?
Well, I mean, I don't know, Stephanie, I just need to be clear on
Sure.
this.
100%.
I'm sorry that everybody else gets it but me.
I think you get it 100% too. Yeah, I think we're all on the same page. Sure.
Here's the problem that I had, and part of it is what Ms. Kruger said, and this pre-1989 thing. To me, that has to be out the window. Why can't we just say, look, it's already R1. Why do we have to do anything at all except for them to, I mean, it's hers. She's going to build on those 2.
Mhm.
They have a deed to their property, right?
Right.
Why, what is it that's driving this? That's what I don't understand.
Sure.
Why is with Ms. I mean, I don't understand why we have to establish that since this was before 1989, that this was split like this, because really it doesn't matter. I mean, it's R1. She could have bought 3 acres or 4 acres or whatever, and she could ask to split. That's what I don't want this to be a reflection that we're doing this and approving a subdivision because it happened before 1989. I'm uncomfortable with that.
It should be something very simple. The fact is, it's already zoned R1.
Mhm.
The land is already there. I don't know why we're coming up with this terminology of subdivisions.
I don't either, because it's gonna screw us up.
I get. Well, can you elaborate a little bit more?
It's already zoned R1.
Mhm.
And she has how much total property? 2 acres. R1.
Right.
Meets the R1 zoning code. Why are we making it more complicated by injecting that we're going to subdivide? When all she had, if it's zoned R1, all they needed is a building permit.
But you have to subdivide that still, because what's recognized right now is what Justice Cadena pointed out earlier was recognized as 545. So that
Yeah.
is what was recognized within that R1 zoning. We changed the zoning back then from RF to R1. And that was
Still
for
bigger
that one strip.
lots.
So we have one strip, one long
Yeah.
strip of R1 that is not legally subdivided per se within the town of Mesilla as 1 acre lots, even though it is recognized as 1 acre lots, can be 1 acre lots. That is not what it is presently. So that's all they're trying to do is say, we're taking these 2 lots that are already recognized by the county as independent records of tax records that
Or
we
having
just
to
wanted.
subdivide them.
So they do have to specifically go through a subdivision process to break up that property because it's all one big lot per se, or three big lots.
3 big lots. And then the only kicker that I keep bringing up the 89 rule is that it's when did the town start to enforce that there is a process to subdivide? Because we could say that whatever the process is in 1989, this is what has to be done. So anyone who wants to subdivide land after 89 would have to follow that process. But before 89, what would somebody do in that instance? So my question is what they did correct? And we don't even have, we can't answer that because we don't have subdivision regulations that told us this is how they should or should not subdivide, or how they should subdivide land in 80. And we see an instance of our code saying that in 89 is when we adopted our subdivision regulations, which,
And to bring up again, maybe we can postpone this and request legal interpretation from our attorneys.
Okay, so is that a formal motion to postpone?
I make a formal motion to postpone until we can get consultation from our attorneys. Town's legal.
Okay.
I second that.
Motion on the floor by trustee Johnson Burek, seconded by trustee Cadena. Is there a discussion on postponement for legal opinion?
I think that the motion we have before us is clear and we're able to do that now. And based on what our subdividing ordinance is now, we would be able to do that now. As far as the other 14 plots, I think we do need to get legal advice and figure out what we're going to do with the rest of that and how to handle that. But the motion we have in front of us, I think we have enough clarity because it follows all of our regulations.
Okay.
And I think, we just confused the situation by bringing in 14. If we had stuck with the applicants, I think it would have been
I agree.
a regular one.
Yes.
I don't understand how we make,
Yes.
like, trying to make it calling it a holistic approach, because it's not. It's just what we're seeing before us. So I think, given what I've heard and you, what you have explained, that it's a defensible position if we had to. There is a premise, a foundation as to what the decision, why the decision was reached. Thank you.
I agree.
One more point of clarification.
Sure.
So it meets the 1989 rule or doesn't?
So, yeah, in 1989, we said, this is what you have to do to subdivide land. You have to hire a surveyor, you have to generate a plat, you have to do it to a certain scale, all of that. But these pieces were already 1 acre pieces as recorded prior to that. So the question becomes, yes, there was not a subdivision plat that was done in 1980 per what is the requirements of 89, only because what were the requirements in 1980?
Right, so
Yeah.
we're still basing that this is legal to do at this point in time because this was established before 1989. So that is the defensible position.
Sure.
Is that, so it's not that it could be done today, because it couldn't be. They haven't met all the requirements.
Well, no. It's that it's defensible in the sense that, like, again, if our code clearly states that the subdivision regulation has its authority from Resolution 89. And so therefore, how do we enforce something that was adopted and declared authoritative from 1989 to a subject property in 1980? We can't. That's the basis of this. So that therefore, I recognize not wanting to do all 4. My question would be, can we amend a motion after this motion to then just make it subject to the 2? Because I don't know if we can feel comfortable making a decision on 2 and not on 14. I'm having a hard time I understand the premise of 14 versus 2, but I don't understand if we feel confident with 2, what's our concern with 14?
I think it's just because what's in front of us is just.
Oh, that's right. I forgot the paperwork about it. Yeah. Sorry. I was like, yeah, fundamentally though, right. So like if fundamentally we can recognize, okay, I can see the perspective for 2, therefore it must then apply to 14. However, we're not acknowledging or asking for 14. So I get that. Yeah.
I still think that we
Sure.
should be in a position to face this again and that there may be.
And I will speak about that because you're 100% correct. And I do this pretty regularly with the county. And so what I have to do, and again, I'm not trying to say that in any way that the county and the town of Mesilla should have the same process. But just as an example, when I come across a property that somebody thinks is 1 acre, but it's a part of 5, but they got a deed recorded in 2002, I say, hey, this isn't correct. The county doesn't acknowledge this as its own legal piece. Well, the tax records show that. That doesn't matter. The county planning department, when you go pull a building permit's not going to allow you. So then I have to work to subdivide it for them. I have to work with the assessors. And so in instances where this situation is mirroring that, I have to tell planning, hey, Albert Casillas, I have some deeds that were recorded in 1992. Can they get a building permit? Yeah, they'll be able to. I have to tell the assessor, hey, assessor, you show this as one piece, but legally there's 2 legal descriptions. And they say, well, is community development okay with it? Yeah. They talk to Albert, okay, cool. And then they'll make that administrative decision. But again, just background for sure.
Can we move to the original motion?
I think we have to do that.
We have
There's
to do-
already a motion on the floor by trustee Johnson Burek, seconded by trustee Cadena
It's
To-
getting a little-
to postpone to get legal opinion. Is there a discussion on that motion? Gloria, if you can roll call vote on that motion.
I want to postpone, yes.
Yes.
I'm sorry, Gloria.
Mayor Fulton Merrick,
No.
trustee Johnson Burek,
Yes.
trustee Nevares,
Oh, no.
No.
So it's up to you, Mayor.
we have
No.
the roll call is 3 noes and 3 yes.
Original motion on the floor with amendment. Mayor Pro Tem Merrick, seconded by trustee Nevares. Open it up for further discussion.
I do think after this vote, we do need to get legal opinion on what to do with the rest of this track, just to make sure everyone else is okay. And if this were to come up again, that we handled it the exact same way we handled this process.
Other discussion. Motion on the floor by original motion by Mayor Pro Tem Merrick, seconded by trustee Nevares for approval of PZHAC subdivision case 062018 as it has been amended with recognitions of the 2 R1 zoned lots. If there's no further discussion, Gloria, if you'll roll call vote, please.
Trustee Cadena,
No.
trustee Johnson Burek,
I'm sorry, I'm just not comfortable with the way it's being presented. I have to vote no at this time.
trustee Nevares,
Yes.
Mayor Fulton Merrick,
Yes.
Mayor Cadena,
Back then.
What kind of slip is that, Gloria?
Yes.
Mayor, the roll call is 3 yeses and 2 noes.
And that brings back memories, Jesus.
Okay. So, PZHA case 062018 has been approved as it has been amended. Next item on the agenda is approval of resolution 2025-40 concerning setback adjustments.
So moved.
Second.
Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Nevada's. We'll open that up for discussion.
The Messiah, it does state that the planning is have the authority to resolution and have it considered by the board of trustees for the purpose of some cases that might come across their desk or their in front of them that would require a decision based on the condition or the case in itself. They recognize that not every single case is going to be governed by our code. Some of them are going to be, as today, some of these cases are unique in itself. Specifically, with that said, specifically with setbacks, there are some properties or could potentially have some properties that the setback could not be met due to geographical, conditions such as maybe a wash or, it's just something that they would feel comfortable having approved in case they do come across a case that, again, would require for them to interpret the code and make a decision when it's presented. Again, it's specifically for setbacks only. For each zone, obviously has their own setbacks, and they would like to have this considered. And I stand by.
Questions, trustees?
I'm just going to make a few comments, Mayor. I think this still gives, not comfortable with having so much power and authority given to staff and to the P&Z. And it's not that I don't trust good judgment will be used. I just don't want to see it also abused. There's no other than when it's being appealed. That's the only time it's going to come to the Board of Trustees. And again, that's why everybody's been saying case by case, and just concerns, especially in our historical zones. So those are my comments. Thank you.
Thank you, trustee. Other comments or questions? Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Nevada's for approval of resolution 2025-40. Laura, if you'll roll call vote, please.
Cadena,
Yes.
Mayor Pro Tem Merrick,
Yes.
Trustee Johnson Burr,
No.
Nevares,
No.
Mayor Hernandez.
Yes.
Mayor, the roll call is 3 yeses and 2 no.
I will note that I need to follow up on that approval, honestly, because I know we have majority, but I think that resolutions require 3/4. So I need to find that out for sure. So I will not call that vote until the next meeting for clarification. Unless somebody on the board knows that off the top of their head. Okay. Next item on the agenda is approval of resolution 2025-41 concerning municipal elections.
So moved.
Second.
Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Johnson Burek. I will open it up for discussion. Benny. Seeing as there is none, Gloria, roll call vote, please.
Trustee Nevares,
Yes.
Johnson Burr,
Yes.
Trustee Cadena,
Yes.
Mayor Pro Tem Merrick,
Yes.
Mayor, the roll call is 4 yeses.
Great. Thank you very much for approval of resolution 2025-41 concerning municipal elections. Next item on the agenda is for discussion only is our wireless communications facility amended ordinance to section 18.54. This is a draft on this one. So discussion all around. Round two. Because there's a lot. And that's the one thing that I want to note, I guess, on a couple of things, because there's a lot of information here, which we already know. We're changing or looking at changing the current ordinance from being 19 pages long to being almost 51 pages long. So there's a lot of extra in there. It's a good things in there as well. And I know members of the committee are here as well as members of the commission. And some of these things, I think that it's important that we look at maybe in the definitions, that we break it down and maybe have some of it in a little bit shorter, clearer segments, that just to work on the length of things. So like when we have under 1854-020 where we have definitions, one example is where we have adequate coverage, just to kind of bring down what adequate coverage is, to be specific on what it is and not be so lengthy and complex. Also in that one, it does have the note of as determined by the town of Mesilla in consultation with the town's consulting expert. But there's no other clarification in this on the town's consulting expert and who that is or where that person may be. So I think we just need some clarification on that. I don't know. And Dasha, if you're more than welcome to answer some of these as well if you want.
Yeah.
Okay. Because I know you worked on this, because we do have the town's expert also noted under complete application and completed application on page 5. And still there under definitions where we have in the application, in the process for application, we're only mentioning the approval or going through special use permit, building permit, and the approval of personal wireless service facilities for the town. But we're not including any type of approval for wireless telecommunications facilities, or WTFs as they're otherwise noted. So I think it's important that we include both of those in that application process if we do that. Let's see. We have, so on page 10, where we're going through, as it's noted in the green there, personal tower is struck from there, and the reasons why. I think that it is important, though, that we do leave some sort of definition in there as to personal tower, because it's been brought down on the bottom there for personal wireless service facility, but we just need to clarify personal tower, because personal private towers are noted there in the bottom and not allowed and prohibited from certain zones. So we just need to have those clarifications on personal wireless facility, personal tower, because I could also see a personal tower as being, as it's noted above in that definition, being one that goes up to have a little receiving satellite for internet. But if we're striking that and it's prohibited, then we just have to be careful with the verbiage that we're utilizing in some of this. Dasha, most definitely.
Yeah,
You worked extensively on a lot of this, so.
yeah, and I want to
Well,
thank
trustee Navarez.
Trustee Navarez for his leadership. Yeah, the term personal tower is confusing, because personal tower means a tower where the end user is a person, but a personal private tower is one that can be used for hobbies and those kinds of things. So a personal tower is actually a commercial tower, but in the industry language, commercial tower means it's for television stations and that type of commercial use, if that makes sense.
Most definitely. And I think that that's why it's because that was another note that I also have throughout a bunch of this is that there's a little bit of conflicting in between the PWSF versus the WTF. They kind of overlap each other.
Mhm.
And the personal towers, as you've noted, are a little bit more they're specific to cell phones and to usage like that. The WTF that kind of conflicts with that in the verbiage and all of this also incorporates a little bit more usage into that, being that it can be for broadcasting, it can be for all of the other uses, kind of like what you've noted, but it can also be on the uses for a larger level. So just a little bit more pinpointing in some of the verbiage, I think, would be great in driving down on some of those
Yeah.
specifics.
Mayor, we took this language directly from the Langley, Washington city ordinance that was done by Andrew Campanelli, who is the leading attorney writing ordinances for small towns in the U.S. That small towns don't have the resources to match the legal power of like a $10 billion company like Verizon or, any of those.
Right.
Yeah. So, yeah, the language is taken exactly from there. And, but yeah, there are definitely areas, like you said, that need clarification.
I just think that it's just a little cleaning up on things, so but otherwise I think clarity is good, on the overall gist. It's just like one thing. So like on page 11, right under section K, where we have a recognition of it says section 106 review, means a review under section 106 in the National Historic Preservation Act. But that's literally the only spot where that's found in this entire document. It's not found anywhere else in that document.
Mhm.
For specifically section 106
And that's in the new copy or in our original
in the
copy?
copy that we have in front of us, because that's why I specifically went through some of these to see, word for word where we're finding it, and
Yeah.
that one isn't there. So I don't know specifically what section 106 review entails. Do you see what I'm saying? So if we're going to have
Yeah.
that, we need clarification on what it is, where it goes, and what it attains to.
So that was black copy, which was our original ordinance. And then the blue copy was the new language from Langley.
Right.
So yeah, I don't know which that
And this
comes
has
from.
the integration of, because this has all the different colors going through that. I mean,
Mhm.
the staff has been really good at working on that, with black being the existing ordinance, red existing ordinance with edits by the committee, green edits by the planning and zoning, and then blue is the new portions adapted from Langley.
Yes,
So,
yes.
So we have
That's
have a rainbow of a document.
I'm
by all
afraid
means,
so.
which is great. And we have, and
Yeah.
it's the one that's been kind of traveling back and forth between all that. This board has not. I have not done any of the noted amendments or changes to it as of yet
Mhm,
by
okay.
this board. So that we did have it in slight discussion in the last meeting, but not in full discussion, because it's a lot of documentation. It's great, but it's good, but there's a lot to cover, in all of it. And I just want to make sure that we nail down a whole bunch of it,
Yes.
all around. And it's going to take a couple of meetings, I would imagine, for us to really get through all of it per se, and really dive down into it, so.
Yeah, absolutely. Yeah, the reason for the growth of the ordinance was to give Messia a little bit of teeth in negotiating with these big companies, so that we have some agency and control. And, the large companies, the only consideration they have is their cost. That's literally the only thing they care about. So if the town of Messia can control things like the studies, where they pay for it, but we supervise it, so that what happened last time doesn't happen, where the studies were kind of meaningless. Yeah. So, yeah.
No, we want to have all the information possible for sure. So, but we need the verbiage to just make sure that it's number one, not overbearing, but also
Yeah.
just straight and to the point is sometimes really good, and then not repetitive per se.
Yeah.
That's what I found in a lot of this is it like for example, we have on page 13, there's where there again still in definitions where we have substantial evidence, exactly the exact same verbiage that is said right here in the definition is repeated in full on page 49
Yeah.
again. So it's just one of those things that if we're going to have the definition, we have the definition, but I don't think it's necessary for us to repeat it in full. We just keep it simple and straightforward to the point. Same kind of meaning with the same part there with undertaking. When we have this full definition for undertaking, and it's only found in 2 other spots in here, and that's on page 55 in section B. And that undertaking specifically talks to the process to go through in that, and it's basically the process that there needs to be a special use permit that is utilized and has to be obtained before this. So we already have a special use permit process. So why are we creating more verbiage and saying we need to have an undertaking when we can just specifically say a special use permit is required?
Yes.
Right? So
Yes.
just simple and easy. Undertaking
Yeah.
is completely struck, and then we just have that taken care of that way.
Yes. Yeah. Us, our group not being lawyers, we just kept the original language because, like, Verizon has an entire building dedicated in Denver, dedicated to nothing else. It's full of lawyers that do nothing else but roll over small communities. So that's kind of what we're up against. So, yeah, not being a lawyer myself, can't say, but we just went with what's been successful in the past.
And then that works completely because that's what a lot of communities do, and we've done that in the past as well. In several different cases, in several different things, and rather than creating something from the ground up per se and reinventing the wheel when something's already been done, then we can follow suit with other areas that have been successful, if you will. And I think that there's nothing wrong with that by any means. It's just the clarity and changing narrative so that it fits the community more than anything. And we have the substance. It's just driving down on the specific.
Correct.
And then also sometimes it's just as you mentioned, it's you're not a lawyer, and I think that when we think about what anybody that might be going through this, this is very intimidating by any means, and rightfully so. It should be.
Yes.
There should be. It should be intimidating, but it should also be clearly read in that. So there's other parts in here, that just in the verbiage, I think that we can do a lot. I understand what's there, like on page 24 when we're talking about height restrictions and concerning small wireless facilities. We talk about it says personal wireless service facilities which meet the definition of a small wireless facility shall not exceed a maximum height of 60 feet above ground elevation in the public use and residential single use or single family zones, and shall not exceed a maximum height of 45 within other zones. That just seems like it's a lot of verbiage that almost borderline contradicts itself.
Oh,
So we just gotta tweak it just a little bit.
Yeah.
Or that's my opinion. I don't know if the rest of the board feels that way, but I think that there's just little things like that that we can look at and fix and clean up, and I think that
yeah.
we can dive deep down into that.
Yeah, when you were asking before about the, what was it, the consultant expert, that's something that City of Langley had, and we wanted to leave it vague enough to see what was the pleasure of the board. If you wanted to hire somebody to represent you who specializes in cell tower processes, that could be done possibly at the expense of the applicant. But again, the city would supervise this person and they would represent you or the town, and not the applicant. Yeah. So that was the intent there.
Makes sense, and I think that it just needs to be more clearly defined
Yes.
in that, so
Yes.
who is this person? Where they come from? Just like what you just said, I think that it's important. Not that I want to add more definitions, but I think that we just need to have clarification on that and just in who this is,
Yeah.
So.
And there are videos by Andrew Campanelli. I believe we've sent out a list of links. The first video by him, it's about an hour long. It is so enlightening. I think it'll, give you guys so much more background than like any of us are able to.
Great.
Highly recommend.
Yeah, I mean, I did listen to him, and prior to coming over here, because I hadn't been involved in doing it, but with the controversy that we've had,
Yes.
and the potential for getting more as things progress in technology, I think I mean, his advice was basically that it is a defense. We have to be on the defense because the corporations have a team of lawyers that are going to try to get whatever they want as cheap as possible. So, I think it, even though it's 51 pages and we can sync it up a little bit and maybe clarify it, I think that that's what the value of it is that it's in defense of what can and will happen under dealing with a corporation. And then we're not going in the long run where we may avoid a lawsuit or,
Yes.
avoid placement in a place that's very controversial or whatever the case may be. So, in this case, I think that the verbiage is real important to keep so that we're protected against the big corporations when they come in and want to do something that is going to be controversial around residents.
Yes.
So, I mean, I'm going to read it line by line, but I did see that there's quite a bit of legalese in it, but it's okay because that's how we're going to defend ourselves
Yes.
in the next
Yeah.
application.
This document is de facto written by lawyers for lawyers. That's the audience.
Right.
And they have their own lingo and whatnot. So,
Because what I gathered, which was incorrect, is that the FCC had made very specific laws about what we were supposed to do. And that was the impression that I got coming into the trustee position, because there was a pile like this on the previous case of all the legal stuff that had been going on since, I don't know, for several years prior to me coming on the board. But the reason for that is because our code was so vague, right? And they were able to take advantage of that. And in fact, the FCC almost is always influenced by big corporations.
Yes.
Whether they're, no matter what administration they're under. So, it is prudent for us to do something to protect ourselves for future, because the FCC, it's Congress as usual that federally, is behind the actual technology. So the technology companies go ahead and bulldoze in their profit-making strategies. So anyway, that's what I learned from that video. I thought it was really good, and I know 51 pages sounds like terrible, but I think it's gonna let us avoid lawsuits in the future.
We actually cut it down from like 110. At one point, it was 110. Yeah.
Well, I personally appreciate your work, Jerry, on this. I know
Yeah.
it was.
Well, I
big.
think the work was done
And-
by the
and
committee, and I appreciate their
Joshua.
help, because, it's good to have residents involved in a
Yeah.
situation like this. My intent was that that the town not be caught up in a situation where it was in a disadvantage when it's at a table with big corporations with a lot of attorneys. I saw that process as the town, at the previous process, the town being fairly helpless to try to deal with the situation.
Yeah.
So this was meant to address that. And I appreciate everybody that worked on it, Dasha and
Thank
Andrea
you.
and Trina and Mary Helen. I'm leaving anybody out, but these people worked a lot to get it done.
Thank you. It
And I
wouldn't have
hope-
happened without you.
Yeah, we really appreciate everybody. I know you're the spokesperson, but it's a journey we needed to take, and I'm glad you were.
Yes.
Thank
Did
you.
it.
Thank you.
In the last meeting, trustees, you requested that I do send it to the municipal league, and that I have sent that off to them for review. And so once we receive that back, I'll have that information back for you on that. Is there any other discussion and changes or sites? If you see any, if you could either email Eddie or myself on those, and we can make those adjustments as needed by the next meeting. Preferably Eddie on that, rather that, so that we don't create a rolling quorum on anything. Any other changes in the immediate for this discussion that are noted?
I just think, like you said, the redundancy throughout the.
Yeah. And then I just wanted to point out some of those that I had noted. So I think it's a great work overall. It's just that there's a little bit of things that we can clean up. So, and it'll be great.
Yeah, I wonder if some of the redundancy is intentional. I don't know.
Yeah. It could be. It's just that there's a few things that just aren't, that they don't jive per se, So I think that I want it to be, in my mind, as strong as it should be. And of course, legal will have an opinion on all of that as well. So it's just those little things. I think we can do that. Any other discussion? Okay. Next item on the agenda is public input, where the public is invited to give any input otherwise noted or that you'd like to talk about for anything, whether it be the cases this evening or any other business.
If I'm not mistaken, I believe that there is a cell tower going up on Nelson Clayschult's property as we speak.
Thank you, Ms. Kruger.
Dasha Bosheva. Have a question about that tower. It seems so close to the road. It's shocking how close it is. Did they measure it from the center of the road or? Do you know, Eddie?
Eddie, you can address that during a little later,
Okay,
because this is only public input and public comments. So
okay, thank you.
thank you. Any other public comments? All right, we'll move into our next order of business, which is Board of Trustee and staff comments, which can include board reports if you have any reports. And I'll open it up to the Marshal's Department first.
Good evening, Mayor and trustees. Don't have much. SROs Boylston and Cogdale got back mid last week from a week and a half SRO training in Santa Fe. So now they're state certified SROs. They learned a lot. They said it was great training. They're going to bring a lot of tools and knowledge to the upcoming school year. So can't wait to see what they come up with. The Durango we've been waiting on, I got the email on Thursday that arrived. I'll go pick it up this Thursday. Came in a lot earlier than they were anticipating. And then Alamo Auto Supply already has all the equipment. So I'm waiting to hear back from them when we can drop it off. 4th of July, we're all ready, or most of my team will be out working for the fireworks show, the concert, and all the other stuff going on. Nothing else major to report. I'll stand for any questions or concerns. No. Thank you. Have a good night.
Thank you. Fire Chief.
Mayor and board, just want to say one thing. I hope everybody got to see the donation of Squad 32 to Mesilla Valley Hospice. That was a very happy occasion for them. They're really looking forward to being able to take care of their patients better. And that's it for tonight. Thank you.
Wait a minute. Hold on. That's it?
That's it.
Oh, all right. Any questions? No? Eddie, community economic development.
All right, economic and community development. Pretty much we're working on the same, we're continuing to work on the same projects we have right now. We are working on record management. We had a gentleman, Greg from Laserfish, stopped by last week and did an inventory or a survey where he gave us a quote based on the documents that we have. I'll be getting with Mayor on that as far as how we can get our records scanned and shredded, providing the proof which ones we can shred, which ones we need to keep. So yeah, he came down and gave us a quote on that. Also, we're working on the lodgers tax. We had, with the help of Jacob up front, we put together a list of the last 2 years who is operating short-term rentals and who hasn't, who has been up on the lodgers tax fees or submission to Mesilla. We did follow up twice. I sent 2 messages already to Airbnb person we had in contact regarding closing or having that communication bridge between us and one of the platforms. He hasn't gone back with me yet, but he did give me a time frame of 2 months originally when we first talked to. So that's coming up shortly, close to that. So again, I'll be reaching out again to see if we can get him to follow up with the information that he stated that he was. For one, he was going to confirm if Airbnb was indeed withdrawing a lodgers tax from the accounts when they were being reserved at that particular time, or if they need to be able to submit payment to the town of Mesilla personally themselves. COG also, Liana's been working on that. She's been communicating a lot with some of the municipalities, also with Carla up north. The next step with that is I'm putting together a draft ordinance or amend an ordinance regarding our historic preservation to meet all the qualifications that the state is requiring for us to be certified with local government. And have a meeting Wednesday with comp plan. I mean, that's exciting. We're pretty much done. We're reviewing the comp plan with Danielle, Mayor, and myself, and to make sure that everyone's heard, and all the surveys are submitted, and we head in the right direction. As far as the comment or the question with the cell tower, my understanding, I was asked that at one point not too long ago. My understanding is whenever it was approved, originally approved by the board of trustees, it was approved with a 250 feet setback from the street, from the end of the street. And then it went into, I was not aware, but it had gone into some kind of discussion behind closed doors, deliberation of some sort that could have changed the distance between 250 feet to 100 feet. And I believe that's what maybe some of these residents do not know that. And that's why they're questioning, thinking it's supposed to be 250. In actuality, it changed to 100.
Well, I don't think so, Eddie. I mean, I don't think, I mean, I drove by there myself. I mean, have you looked at it?
I haven't been down there, to be honest with you.
I think that everybody understood that we had to follow the ordinance, right? And that's why the big ordinance is coming up, because we said 250, planning and zoning said 250, but the ordinance, I think, even said 60 or 75.
It's
75.
plus 10%, yeah.
Yeah, so that's, it looks like, I mean, it's big, just perception wise, but it'd be nice to just check it.
I go down there tomorrow and look at it.
And just make sure it's just the one that we agreed to, because they talked to me and it doesn't seem like it's even that 75 feet.
Okay.
So that's why she's trying to.
Yeah, because I haven't looked at it, but tomorrow I'll swing by and take my rangefinder and get the measurements.
I mean, I don't know how they did it, and maybe it's because of the structure itself, and they didn't start at 75. They started inside the 75 to build a structure. I don't know.
I think I'll definitely take a look at the verbiage on that, because I think the 75 feet plus the 10% is based on the cell tower itself, not the facility surrounding the cell tower. And because of that setback, in case there's a danger for the cell tower to fall down, you need that additional 10% to be away from the property line. I think, again, I have to check on the verbiage.
If you don't mind, because
Sure.
I've had a lot of people comment that it just seems closer even, and they're not confused about the 250.
Okay,
Because they know that got struck down.
okay.
When you look at the plans as they were approved, though, just as a comment on that, and what we did in how it was revised ultimately
Right.
with that is that it was to go back 3 trees. And there's three trees that have been fully removed where it is presently sitting. So the perception is because of what it is and the height and it does seem, I drive by that thing every day, so it does seem close, but I feel confident that it's the required setback that it needs to be.
Okay. Well, if we could just address it officially and say you've looked at it.
Yeah, we'll look at it.
For sure. Like I said, I haven't stopped, but I'll drive by tomorrow. Confirm it. That's all I have.
Thank you, Eddie. Or Mr. Salazar, sorry. Finance, Ms. Maya.
Staff is starting all the process for the end of the fiscal year and entering everything for the new year. I think you'll be very happy to hear that our Cherokee came in very high, more than what we expected. So
Told you.
I was really scared at the beginning of the year, but this was our last one for this fiscal year, and it came in really good shape.
And we're going to start the next fiscal year off strong.
Yes, and we're starting the audit process.
Thank you.
Cool.
Lorenzo's out on vacation, but just he's got quite a few projects that are still going on. He's out until the first week of July. Manny is in his stead, taking care of things and doing a great job at that. As Lorenzo noted in the last meeting, the university project is underway. Their anticipation is to try to get from McDowell going west to Avenida de Mesilla completed and ready by the time school starts back up towards the end of July. And a lot of residents have been contacting me right there in the subdivision that's right across from Zia. I can't remember the name of that one off the top of my head, which I apologize for, about trash service and all of those services. And we are aware of that and working with our solid waste company for pickups on and issues that they're having with the communication and getting back and forth. So we're working with DOT as well as our trash company to get those things figured out. The sidewalk improvements along Santiago are almost 100% complete, and they are moving quickly to try to finish up the Santiago Bridge, as well as the parking lot and parking lot improvements by the end of the month. So hopefully by next Monday at the very latest, that project will be at almost 100% complete, I think is the contractor's goal. I do have a meeting with them on Thursday to get full updates on that and where we're at with that. So we do not have an update on the well. As I had told you the last time, they pulled the motor off of well 1 and they're doing tests on it to see what's going on. I believe that Lorenzo told me that he was told that the pipe itself was fine, so it might just be the motor on the well. But they're evaluating that, and hopefully by the time he gets back, we'll have that figured out and what that's going to cost to get that repaired. And that's that on that part. So I'll pass it off to Trustee Nevares.
Yes, I had a meeting and discussion with the director of community economic development just to catch up and discuss whatever's working on right now. It was a good discussion. Also, I'd like to comment on the Calle Santiago improvements and the sidewalk improvements. They're great. I mean, it makes it a lot walkable, more walkable than I've ever seen anything. Some of those sidewalks were difficult to maneuver. Now it's a very easy walk. So good job on that. Thank you.
Awesome. Trustee Johnson Buick.
We had a MPO meeting on June 11th. We discussed the proposed evaluation process for the executive director. We got a presentation on the Metropolitan Transportation Plan for 2050, presentation on New Mexico Department of Transportation Aesthetics Plan, and then the 2025 MPO Quality Assurance Review that is done by New Mexico Department of Transportation on our MPO. No meeting for July, and we will resume again in August, first Wednesday of August. And that's all I have, Mayor.
Thank you, Trustee Johnson Buick. Trustee Cadena.
The Friends of the J. Paul Taylor Historic Site aren't meeting in June because some of the officers and administrators are meeting with the new state director of historic sites. So I don't know, Mayor, were you able to attend that
That's coming
dinner?
up.
Oh, it's coming up. Okay. So that's going on there. And I actually missed the book launch. So I'll have Mr. Mayor, if you could talk about that a little bit, please. And so that's all I have. I have missed the last 2 meetings, so I feel like I'm super behind on everything, but I've reviewed all the comments and the paperwork on it. That's all I have.
Thank you, Trustee. Mayor Pro Tem.
So Lorenzo's been out of town, so I haven't gotten any updates or had any discussions with him. We don't have a meeting at MPO, like Trustee Johnson said, but our next one will be at the Las Cruces Chambers, right?
Yes.
And other than that, I don't have anything else.
That's it.
That's it.
You guys make it all easy. So to touch on the book launch, the Friends of the Taylor Monument did have that book launch for Mary Daniels Taylor's book, and that was it was greatly attended. It was probably about.
It's supposed to start
Yep, there's lightning.
the next 3 days.
All right, we'll make there was probably about 50, maybe 60 people in attendance, and they did sell quite a few books that day. It was a great little deal there. So I personally did have a press conference with Congressman Vasquez that we did jointly with a few other people concerning our Oregon Mountain Desert Peaks National Monument and trying to preserve that, where the new Secretary of the Interior is trying to dismantle that. So hopefully we can maintain our monument, and I'm going to be bringing forward a potential resolution to the board in the upcoming weeks to help have support to give nationally from the town of Mesilla for that. So just a heads up on that. I did have a grant training meeting with the Municipal League. As it was mentioned, I do have a meeting with the new executive director of the historic sites coming up. And then we do have an advisory meeting for the monument afterwards with all of that going on. And then South Central Regional Transit District does have their meeting this week as well. So I'll be going to that. Or Trustee, are you going?
I don't know. I mean,
Okay. We'll figure it out. No, I'm not on that one.
You should tell me that you're not going to.
Yeah.
That's
I know that the one the meeting next month is one that the chairperson won't be able to attend, so he asked that I do go and chair that meeting for him. So I will do that for sure and be there, but I'll talk to you on the other because we'll see. And then we did have we had a couple of meetings for our municipal ordinance jurisdiction committee, and there was a recommendation from that committee that will be coming to the Board of Trustees probably by the next meeting. There were a few questions that were unanswered that we're still trying to get answered, but that was not anything that did not impede on the recommendation. So we'll have that to
We
you.
have a leak, Mayor.
Oh boy.
It's a drag.
Good thing GRT was up.
Right. Don't say that. That's all we want to spend it on. Oh my gosh. The one with that noted, I do want to ask the board, just because we would not have our next meeting for over 3 weeks until the 14th of July, and it is the first meeting. If we did it on that date, it would be the first meeting of the fiscal year, which you know that there's a ton of resolutions and everything else on top of everything, all the other business that we would need to be reviewing. So my question is do we want to tackle all of that at that meeting on the 14th, or would we like to call a special meeting ahead of time to address some of the regular business after the new fiscal year starts? So potentially the Tuesday.
Say that again?
2 meetings or
3 hours or a 3 hour meeting.
You think it would be 3 hours? Probably gonna be longer than 3 hours.
Two meetings.
2 meetings.
Yeah.
So we'll probably, since Planning and Zoning has their meeting on Monday, July 7th, we'll probably do a special meeting on Tuesday, July 8th.
Okay.
Is everybody? Does that work?
So,
And then we'll have our regular meeting on the 14th as well.
perfect.
All right. And if there is no other discussion or if there's no other discussion or objection, I will call this meeting as adjourned at 8:35. Everybody be safe and stay calm. Don't get very frustrated, but it doesn't happen. It's not supposed to be like it.
So where's the trash can?
You don't know how train is supposed to be
No.
going? That's not.
It's not here.
Trash can is not.
Oh, text us on your
What's that?
I don't know. Which one is it? Oh, it's all.
You got it. I know.
We were gonna ask. You're welcome.
Let me go see.
Nice job. This one will go there and that one will go here. It's gonna need more.
Yeah, you okay? I'm okay. They are. Hard, they move forward. I didn't bring an umbrella. Very.
Is this the one you brought?
That's the one I brought out of the boardroom, yes, sir. All the rest of them had trash. Like they were full.
I was gonna say, don't judge my trash can because. Oh my gosh.
That's a good one. That's probably just leaking up into there. It's just.
And just traveling, yeah. I guarantee you that's what's going on. All right, I'll go grab it.
Would it be worth it, pop on a tile, and seeing where it is, and then put the trash can right there? I do, at work. Now's the time I need coal here.
Not gonna be much we can do about it. It's leaking roof.
Just catch it. I don't think we put on the ladder. The ladder here.
All I can do is climb up on this stuff. That's all I could do.
That'll be great for coal.
What's that?
This is when we need coal, like, to.
One, because he can
We
just
don't have
go.
a ladder with us.
Switch with the here.
I mean, it's only supposed to rain for what, 24 hours?
5 days.
Sorry, 5 days? 5 days straight? No,
Ooh, there's some, like,
not let up? Let's see what happens, right?
And at the bags, I didn't know if that had a hole in it. A lot of these cans have holes.
Still on.
What's that? Still recording?
Oh, well, they can catch us playing with the flooding.
I don't think he's got any bathrooms. I was waiting for it too. I was just watching Laura. I was like, Laura probably needs to move.